Hi guys, welcome back to my channel. In this video we will know about the valid condition for solemnization of marriage under Muslim law. After this case study we will know about what are the essentials of valid marriage under Muslim law, what will be the effect of Muslim marriage. So this case is all about the validation of Muslim marriage term and condition should be flawed while you performing the marriage under Muslim law. So before this case study, I just overview on the history of Muslim law. After that, we will connect this the provision of the Muslim law to this case. Okay. The Prophet Muhammad, after death of Prophet Muhammad, the question arises over the community that who will now regarded as successor of Prophet Muhammad. So some community says their descendant will be the prophet, successor of the Muslim community or Muslim religion. Someone said the heir of the Muslim Prophet Muhammad, that is Abu Bakr. So by this view, the Muslim law divided into two sects. First one is Shia sect and second one is Sunni sect. You can say first one is Sunni sect because of majority and second one is Shia sect, who followed the Abu Bakr and the Prophet Muhammad come under the Sunni sect, and the son-in-law, that is Ali, and the Ali's flower is regarded as Shia sect. Okay, in this world, the Sunni's the Sunni majority is vast. That's why Muslim law is regarded as also Sunni law or Shariat law. 1937 or 1939, just cross check about the date of the enforcement of the Muslim law. Now, in Sunni sect, there is provision regarding validation of Muslim marriage. So this case is all about the validation of Muslim marriage. What is the condition if you want marriage under the Muslim law? So first condition is capacity of parties. Now the Muslim marriage is regarded as civil contract, not sacrament, but some thinkers is also regarded as Muslim marriage also a sacrament like Hindu marriage, but I will not cover that aspect, only focus on civil contract. Why this marriage is regarded as civil contract? The reason is simply the capacity of contact under the Indian Contact Act 1872, like that the parties should be sound mind, parties should be major, the proposal and acceptance also there, the consideration is also there, the free consent is also there. Due to this provision, if you compare the essentialities of the valid marriage under the Muslim law, the provision of after comparison you found this lightly same. That's why the Muslim law is regarded as civil law contract other than sacrament like Hindu Marriage Act 1955. Okay, so I hope you will lightly understood the what is the reason behind the civil contract regarded to the Muslim law marriage. Okay, so now look at the second ingredient, that is the proposal and acceptance under the Muslim law. The proposal and acceptance. Now in Arabic, not in Arabic term, a term namely ijab or kabul. That means ijab means proposal and o kabul means acceptance. That is, proposal acceptance must be there. Okay. Third ingredient is witness. During the performance of performing the solemnization of marriage under the Sunni law, there must be two adult witness or one adult and two female adult is mandatory. Either two adult witness or one adult or two female adult is mandatory during the marriage in same same meeting mind. Okay, so same transaction of marriage or same manner of marriage, the two witness is required. Okay, the last ingredient of the marriage under the Sunni law is meher or dower. Now don't be confused regarding meher or dower, both are the same. The meher is the Arabic term and the dower is the English term. Okay, the in Sunni sect, the during the marriage must the meher provision should be followed. But if you see in Shia sect, there is no provision regarding witness or requirement of witness while performing the marriage under the Shia law. But at the time of talaq under Shia law, witness is required. Okay, so now just look at the fact of the case. What is the fact? Then after we will come on the contention of the parties. Then after analysis of the court and observation and reciprocity of the case. Then after the judgment and conclusion. Then after we all know about the what is the correct point of the case, that for the validation of the marriage under the Sunni law, the essentials should be followed. Okay, now come on the fact of the case. This case is based on the valid marriage conditions. I earlier said the judgment was given by the Justice Mir Mohammad. Okay, the fact of the case: Mohammad Shafi sued Ghulam Kubra, that was the plaintiff, and the Mohammad Shafi, the respondent, for the restitution of conjugal right. Now, a term restitution of conjugal right is not anywhere written in the Muslim law, but it's written in the Hindu Marriage Act 1955. The conjugal right is awarded to the both party under the Hindu Marriage Act for the restitution of conjugal right. In case of without any valid reason, if you live separate from either husband or wife. In case of husband, if husband live without any valid reason from the wife, and the wife live without any validation of the without any valid reason from the husband, in that provision there is a concept regarding the conjugal restitution of conjugal right. This right is given to both under the section 9 of Hindu Marriage Act 1955. If you can see if you then after you able to understand the legal meaning of the restitution of conjugal right. Okay, so the similar provision is also under the Muslim law due to the civil contact for that purpose it is awarded. Okay, so Mohammad Shafi sued Ghulam Kubra for the restriction of conjugal right. Okay, now Ghulam Kubra Bibi filed an appeal in the High Court against the decree of the District Court. The District Court issued the decree granting the restriction of conjugal right. The District Court gives the decree on the lines or judgment of the trial court that the Kubra Bibi's nikah was done at the instance of her grandfather and her consent was not sought for his marriage, and it was proved that she was the 17 years old at the time of the marriage. By using this fact, the trial court awarded the restriction of conjugal right and the marriage was valid as per the trial court. Same judgment was flowed by the district court, and the proportion of the injunction, that was the contents of the respondent Mohammad Safi, that there should be the injunction against the parent of the Ghulam Kubra also be issued in the interference of the marriage relationship, but the district court was don't think that the injunction should be awarded, so the proportion of injunction was set aside and continue with the restriction of conjugal right and the validity of marriage of both. Okay, now the contention of the plaintiff was that the main contention of the plaintiff was that the never she was never married to the Muhammad Safi. Now, what should be the reason behind that? You can see a further point after you will become know the reason, what could be the reason that this contention. Now come on the contention of the defendant. Mohammad Safi's contention was for the restriction of conjugal right, that is FCR. He also wanted the injunction, as I earlier said. Don't go to there. But after before move ahead, you also know about the capacity of party and the essential of the marriage, like the capacity of party, proposal, acceptance, witness, meher. Okay, so now you can also know about the meher is regarded as consideration. That's why the under nikah under the Muslim law is also regarded as civil contract, pure civil contract. Now, what is the ratio and analysis and observation of the court regarding this case? The court opined that the parties, of course, the plaintiff respondent are there. The parties were under the impression that the age of marriage is 18 years as the general laws, and presumed and presented. Okay, it is because that Ghulam Kubra Bibi was not consented and the grandfather gave her away. Now, this line I am going to tell in Hindi. कोर्ट ने यह समझा कि एट द टाइम इवन द प्रेजेंट era everyone all know about the majority age is 18 years. So the गुलाम कुबरा के ग्रैंडफादर थे, वो सोच रहे थे कि मेजोरिटी एज तो 18 साल की होती है, ठीक है, और गुलाम कुबरा तो अभी 17 साल की है, तो उसका कंसेंट रिक्वायर नहीं है। माइनर सेंस में उन्होंने सोचा कि मैं खुद अपना लीगल गार्जियन हूँ, मैं अपना कंसेंट देता हूँ फॉर द परफॉर्मिंग द मैरिज। दैट्स वाई आई डोंट थिंक ग्रैंडफादर की उसका कंसेंट रिक्वायरमेंट है। सो गुलाम कुबरा was gave away regarding consent. Okay. Further, court observed that the girl was 17 years old and under the Muslim law, measure as per Muslim law, age of puberty is required. It is the 15 years. Okay. For the nikah, but consent of the parties becomes necessary in case of majority. But in case of minority age, like the below the poverty age, that is 15 years, the legal guardian is entitled to give the consent for the performance of or solemnization of marriage. But there are some circumstances, certain circumstances uh, after that, the in minor case, the marriage will become null and void. So it seems that it is against the right if the without marriage, without the consent of the party in case of majority, it seems that it is against the right when the named parties are married by their legal guardian without their consent. But in case of minor girl, it is permissible in the Muslim law that her father or grandfather or other paternal relations should give her away, and the marriage will still become valid. Now we have a act, namely the provision of Child Marriage Act 2006, and that act's section 12 regarding the age of minority is marriage. So look at the that case for better understanding. Now see the provision of Child Marriage Act 2006, section for the point of case, section 12 is necessary to know. Okay, the section 12 is about marriage of minor child to be fired in certain circumstances, where a child where a child being a minor, of course minor, is taken or enticed out of the keeping of the lawful guardianship, or by force compelled, or by any deceitful means induced to go from any place, or the minor is sold for the purpose of marriage and made to go through a form of marriage, or if the minor is married, after which the minor is sold or trafficked or used for immoral purposes, such minors shall be null and void. So these are the provision, these are the circumstances. Being a minor, the marriage became null and void. So this is the very uh, must know in case of minors. Now come on the case fact. So the further, if you look at the witness criteria of valid marriage, the witness provided by the respondent were Mohammad Ramzan and the Mohammadin, both presented before the court. The mullah, one who read the nikah regarded as mullah, presented in this case, informed the court that there was no one who sent to the girl to inquire from her whether she was a willing party, she wished to getting marriage or not. There was no any circumstances was sent to the uh, by the relative or relative to the girl to know about their wish regarding marriage. So these circumstances tell about the lack of consent of the girl, that is the Kubra Bibi. Okay, and this marriage was done on the insistence of her grandfather. The witness only witnessed the nikah, not the consent of the bride. Okay, the Kubra Bibi, that the girl, that that the girl was 17 years old. So the judgment after the analyzing observation, the ratio or region. The judgment. What was the justice name? The justice name is Mir Ahmad. Justice Mir Ahmad says that Ghulam Kubra marriage is not a valid marriage because you have not followed the four essential ingredient of the valid marriage under Muslim law. That's why the valid marriage is not a valid marriage. Okay, and the appellant cannot be provided with the institution of the conjugal right, and that the appellant is the respondent, that is the defendant appellant is Mohammad Shafi Mohammadin. Okay, not provided with the restriction of conjugal right, and the appeal of the Ghulam Kubra Bibi was accepted, and the suit of the Mohammad Safi is dismissed. Okay, so the conclusion is like that the stance of the court was very correct in this case. The practice of the two witness is the mandatory uh, and or necessary in the marriage of the Sunnis. Out of the four measure, the witness considered as a necessary element. Marriage under the Muslim law is a civil contract and the fulfillment of the all condition is to be necessary. So this is the case regarding the validation of the marriage under the Muslim law. I hope you will be able to understood regarding the validation of the marriage under the Muslim law. Thank you so much for watching this video. If you want this PDF, you can give me a comment in the description box. I will share to you. You can also contact me on my Telegram. My Telegram ID is Prudent Rahul underscore like or Rahul Prudent underscore like. Just keep check. Thank you so much for watching this video again. I hope I am able to I will able to make you understood. I was able to make you understood. Thank you so much again. I am gonna to sleep because it's too late. That's why my word was fluctuated. Thank you so much again. Bye bye. Take care. Good night. If you have any suggestion, you can suggest me. So thank you so much. Bye bye. Take care.